Good evening, I'm Jim Zirin. You're watching The Digital Age. Lawyers have traditionally charged clients for their services in accordance with the time spent on a matter. Abraham Lincoln said, "A lawyer's time is his stock in trade." Our guest tonight, Richard Susskind, has challenged this basic assumption. In a provocative, best-selling book entitled The End of Lawyers, ? Richard Susskind argues that information technology has fundamentally changed and will continue to change the way lawyers work and charge for their services. So here from London is Richard Susskind. We're delighted to have you with us.
Great to be here, Jim.
And welcome. Now, Richard, you are a Scots lawyer. You're an author, an independent advisor to major law firms, general counsel, and national governments. And you write a book entitled The End of Lawyers. What do you mean by all that?
I should stress it's the end of lawyers ? I'm asking the question in the digital age whether or not lawyers have a future or how the work of lawyers might change. And I think it was interesting to put a title into the market like The End of Lawyers because I needed to grab people's attention, and that it seems to have done.
What is the essential thesis of the book? What's your argument?
This is accelerated by the current economic conditions, is that lawyers need to find ways of reducing the costs of their services. Whether the clients are major multinational corporations or individuals, consumers, legal services are just costing too much, and we need to find ways of charging less and of working differently so the costs come down. So my major response is that we need to look at legal work and decompose it, deconstruct it, break it down into its constituent parts, and ask of each of these parts, what's the most efficient way of doing this work? Do we do this work differently? Traditionally, clients thought, do I do this work myself or do I give it to lawyers to do? If you give it to lawyers and law firms, they did the whole lot. What I'm saying is you can actually break down legal work into different parts and source each part far more efficiently in the past, and this will mean radical reductions in the cost of legal services, which is what exactly the market requires.
Does your model apply to all work that lawyers do, or just some of it? I mean, if we were to deconstruct, as you have, services lawyers render, particularly in large law firms, you have document review and legal research, project management, litigation support, and on and on and on. Does your model of deconstruction and standardization of these services apply to everything across the board?
It certainly applies insofar as you can see so far to every broad area of legal practice. So if you look at, for example, the conduct of a big dispute or the conduct of a major transaction, we see elements in each of these that I believe can be done differently. Once you get down to a level like advocacy, for example, which I argue is one of 9 parts of the litigation advisory process, that itself perhaps can't be decomposed any further, and advocacy, it seems to me, particularly in the United States, is an essential job that is undertaken by lawyers. But if you look at something else in litigation like project management, and many lawyers say to me now they're not lawyers anymore, they're project managers. I believe that actually other organizations can undertake project management currently more efficiently than lawyers. If I look at the big accounting firms, if I look at consulting firms, they take project management far more seriously. They invest in the systems, the processes, the techniques, the new ways of working that really constitute project management. For many lawyers, project management is about buying a new set of lever arch files and using some yellow stickies. It's about being a bit more organized. This is not project management. That's just saying you're engaged in project management. So my point is not that lawyers can't engage in project management, but the current way that they do engage in project management actually is substandard, and we can go to other providers. A challenge for lawyers: if you want to be in project management, you tool up, you train up, you do it as well as competitors. If you don't do that, you can expect other professionals to join the market.
Now, lawyers, and you are a lawyer, as you know, have always been an unpopular profession. I mean, Shakespeare's Dick the Butcher said the first thing we do is kill all the lawyers. I mean, is this approach that you take so much more lawyer bashing, or do you think that it's something else?
I think it's not lawyer bashing. As you say, I'm a lawyer myself, and some indeed of my closest friends are lawyers, and indeed my clients are lawyers. I think the punctuation mark, the question mark, really keeps me in my job. I advise lawyers work closely with me. Depends what kind of lawyers you're thinking about. imagine lawyers in-house in major organizations. They actually very much, it seems to me, approve of what I've got to say because this allows them to get better service at lower costs. So that category of lawyer is actually welcoming my work. Also a category that seems to welcome my work.
Well, they're consumers of legal services.
Consumers of legal services.
They're speaking from the client's point of view.
That's probably right. They're still lawyers, though, and you were asking whether or not lawyers felt threatened or whether or not it was lawyer bashing. So that's a category of lawyer, albeit their clients, who I think are supportive. Then you've got innovative law firms, and there are many who actually are trying to find new ways of working, new ways of competing, new ways of meeting clients' expectations. They too, it seems, welcome the messages in my book. Those who don't, and those who feel threatened, and those who in turn would say that it's lawyer bashing, are law firms who want to hang on to traditional ways of working. They don't accept the digital age. They don't accept they should move from handcrafting, from a highly, as I call it, bespoke, handcrafted service.
Now, bespoke, that means what we call custom made.
Yes, I'm often very conscious that in the US you don't use the word bespoke. If you have a handmade suit tailored for you in London and Savile Row perhaps, we call that a bespoke suit. And I argue that much legal services handled or regarded in the same way, that people think that the way in which the solution is crafted is highly customized, highly tailored to the particular circumstances of the client. And what I say is actually quite a lot of it can be off the peg, can be off the shelf, it can be standardized, it can be systematized. Now that argument is not bashing lawyers, it's simply saying in the digital age, we can find different ways of delivering legal services. I have nothing against lawyers, though I would say, and it's controversial, that I don't believe the law is anymore there to provide a living for lawyers than ill health exists to provide a livelihood for doctors. We are not, as lawyers, entitled to legal work. It seems to me law is fundamental in society. People need legal guidance, but if the market is requiring lower costs, we have to meet that challenge. Simply to ring fence what we've always done, or to charge in the old ways, or to say we can't change, seems to me is unacceptable.
One of the ways that we can reduce cost is by being risk managers rather than first responders. In your presentations, you've used a marvelous cartoon of a man looking over a cliff at an ambulance. If we can prevent crises from occurring, we can, of course, save clients a great deal of money.
I think that's
irrespective of how we charge for the service.
Absolutely. I think that's fundamental. One of the running themes of the research I do with in-house counsel is precisely as that graphic illustrates, that clients would prefer a fence at the top of the cliff rather than an ambulance at the bottom. Clients say to me, we don't want dispute resolution, we want dispute avoidance. I'm yet to meet a chief executive who would prefer a good dispute well resolved to not having one altogether. People want to avoid pitfalls, and it seems to me this is a challenge actually the profession has not really met. I look at the tax profession, I look at the way they handle tax risk, the way they identify, quantify, control, manage, hedge, monitor tax risk. They use sophisticated tools and techniques. In law, we haven't developed analogous techniques to help clients not simply resolve their problems, but say, on the horizon, here are 4 problems you're likely to face, and here's how we suggest you manage and control these.
You've been working in this area for about 30 years,
That's right.
Isn't that right? Now, when you got started, let's say in 1996, there was considerable resistance at the English bar to your ideas. Isn't it true that the Law Society, what we call the Bar Association, didn't want you to speak in public?
Yeah, I think many people don't want me to speak in public. At the time, I was suggesting the dominant way that lawyers and clients would come to communicate would be by email. I know in retrospect that sounds rather obvious, but at the time it was pretty radical thinking. And senior officials in the Law Society in England and Wales were saying that I didn't understand confidentiality, I didn't understand security, that I was bringing the profession into disrepute by suggesting we use email. And it seems to me, of course, that that was, at the time and in retrospect clearly, was silly, that we should, in the profession, embrace new techniques, new ways of working that are proven in other sectors. And much of what I say, actually, is not great insight and my own imagination. I look around at other sectors, at other industries, I see what's worked for them, and I think, what if we applied that in law? Why aren't we using social networking in law? Why aren't we auctioning services in law? I look at a whole bundle of emerging and existing technologies and techniques and processes and systems and say, I don't see why legal services, I don't see why lawyers should be immune from these changes, these new methods that are working elsewhere. Some of them may need to be refined, some of them may need to be changed, some may indeed be inapplicable, but we have to be open-minded, and above all else, that's what I ask from law firm leaders, be open-minded, consider there might be different ways of working.
Isn't the argument, though, in many respects economically driven, and it applies in a way that's perhaps perceived by lawyers as unfair in the area of services? I mean, if I want You would say a Rolls Royce, I would say a Cadillac. I expect to pay for it. And in the area of services, clients now are naturally, because of the downturn in the economy or otherwise, no one likes to spend, are clamoring for more and want to pay less.
Yeah, I think that's right. It's absolutely right. The Rolls-Royce service is an interesting point, because I think what many clients say to me is we need a Rolls-Royce service on some occasions, but we'd be quite happy with, say, a Mini on others. There is an interesting concept one hears from a lot of clients that some service is good enough. In some particular circumstances, they don't need the highly polished, perfect legal service. They need pragmatic, practical, punchy, jargon-free, immediately implementable legal advice, not wonderful legal analysis of the black letter law. So there's a question, I think, about what kind of advice clients really need, whether or not on all occasions they need the Rolls Royce. The economy point's terribly important, though. I'm conscious that, say, 4 or 5 years ago, I used to stand up in front of partners and law firms.
Those were the lush years.
These were the good years. And I used to say, I understand it's hard to convince a room full of millionaires that you've got your business model wrong. The reality is it was good times. There was no shortage of work. It was a seller's rather than a buyer's market. Lots of business, deals, disputes. And so this strange Scottish person standing up and saying the world is going to be very different, you should work differently, they were saying, why on earth? Why should we change the business model? It's working well for us. And really my idea is, up until 2 or 3 years ago, globally weren't receiving traction. Now they do, because the economic constraints, the financial difficulties, the demands of clients to say we need to reduce our external legal spend by, say, 50%, that is now causing law firms, even the finest, to think, actually, we need to move on. And even more, many firms are now rationalizing and say, of course, we always said that change was inevitable. They didn't always say it. It's only been over the last couple of years. So the economy, in a funny old way, has been a catalyst. It's accelerated the kinds of changes I've been predicting over the next 30 years. A big question that many people ask is, well, when the economy returns, when there's great deal flow, when the market's healthy, when the dust settles, won't the landscape look just pretty similar to 4 or 5 years ago? We'll be back to the old ways.
Put the genie back in the bottle.
Indeed, toothpaste back in the tube, and I don't think you can. I think, frankly, now we've seen there are new ways of working. Now we've seen we can reduce the cost of due diligence. We've seen we can reduce the cost of basic contract drafting. We can reduce the cost of document review and litigation. Why on earth would any client want to pay more? The more for less mantra, as I put it, I think will underpin the next decade of legal service. Chief executives, shareholders, chief finance officers have now seen that legal services are not unassailable in terms of their costs and so forth. We can break them down, we can charge in different ways. So it seems to me it's the beginning of a transformation, a revolution in legal services. I call it an incremental revolution. It's not a big bang change overnight, but over the last 2 years, we've seen sufficient changes in the way that we might deliver legal services that I think is irreversible.
A lot of the criticism that's heaped on lawyers is the time charge.
Yes.
It's said that my lawyer picks up the phone to talk with me, immediately I'm going to be charged. If the lawyer has lunch with his or her colleague and they talk about the case briefly, I'm going to be charged for an hour and a half for lunch. Is it necessary to change this model of time charges and billing rates? And then also, as you know, in a large firm, the time spent on a matter is pyramidal. The partner at the top of the pyramid spends relatively little time. The associates at the bottom who are doing legal research and reviewing documents are spending a lot of time. But lawyers would argue, well, that's how we develop the fee.
Yes.
And it has really nothing to do with whether you think that the service performed by the junior associate is worth what we're charging. We're charging it because we have a training program and we have the associate's salary, and because that's all built into the fee we charge for Cadillac services.
Absolutely.
What's the answer to that?
Well, there's several answers because there's actually several questions. Let me take them in reverse. In a sense, you're talking about the pyramidal structure. Fundamental to the profitability of law firms, you have, as you say, at the top, you have an expert partner, lots of junior lawyers, basically junior lawyers being charged out at fees that represent a lot more than they are actually paid. That's where the profit has come from. If you've got 30 junior lawyers reviewing documents at several $100s an hour, you will make lots of money. My fundamental challenge is precisely to that business model, the pyramidal structure, because what we're seeing is that routine and repetitive work at the bottom of the pyramid that used to be undertaken by junior lawyers can now be done in different ways, whether by paralegals, whether automated, whether outsourced or offshored. That is such a challenge to the business model of many law firms. So I do think that is severely under threat. Let's go back to the question though, and I suppose in many ways the bigger issue of how we charge for our time. On the one hand, it's clear to me that charging, for example, for having lunch seems to me to be inappropriate and unacceptable. But assuming that all the time is charged is broadly sensible, does it make sense for that to be a way in which you charge for your services? Well, I think my daughter answers this far better than I do. A couple of years ago, she wanted a summer job. She was 12. I said I needed business cards put in Outlook. Would she do it? She said yes. She said, how much are you going to pay me, Daddy? And I said, I didn't really think about it. I thought, well, I'll just pay you by the hour. She paused for about 2 seconds, smiled at me and said, well, I'll take my time then. Now, it seems to me if a 12-year-old can see the problem with hourly billing, that what it basically incentivizes, unconsciously or consciously, inefficiency, then why can't the clients of lawyers see similarly? I'm actually not strictly saying that hourly billing is inappropriate on all occasions. For me, going back to the bespoke notion, where the service is genuinely bespoke, where I need you, Jim, as a lawyer, to do genuinely strategic, imaginative, creative work for me, I don't want to say you've got 90 minutes to do that. I shouldn't say you're restricted in terms of how much time by some kind of fixed cost. So I believe hourly billing, time-based billing, is sensible. It makes sense as a way of charging where, frankly, the work's open-ended and we need genuine expertise and we need to give our advisors some space to be creative. But what I so strongly argue is that a huge amount of what goes on in the law office doesn't fall under that heading. A lot of it's routine and repetitive, it's well systematized or standardized, we know the scope of it, we should be able to say to a client, this is what it's going to cost, it's a fixed cost. And vindication for this whole theory, it seems to me, comes from recent experience in the market. When clients do say to law firms, we'd like you to do this work on a fixed fee basis, what a change in behavior, because suddenly the incentives switch. Suddenly the law firms actually are incentivized themselves to do that work more efficiently, because if they can do that work more efficiently, it's more profitable for them. So we've had the incentives in the wrong place. That's the fundamental difficulty with hourly billing. It actually discourages law firms from being as efficient as they could be. So in summary, I think the pyramidic structure is under severe threat. I think also hourly billing should be restricted to genuinely bespoke service. You raise, though, a third issue, and that's about training. And this is a complex one, because many people say to me, well, if what you're doing is now undertaking routine and repetitive work beyond the law office, what are the junior lawyers going to cut their teeth on? How do you become an expert if that work's no longer done in the office? And it's a key question, and I have a whole bundle of different responses to it. I think, and they're in the book, and I would say this, but I think they're compelling. One interesting piece of feedback is I asked junior lawyers this. I said, what do you think? Are you going to lose your training ground? How are you going to learn your trade? And a uniform response that came back from junior lawyers is say, it is useful, and of course we learn a lot from, for example, doing one exercise of due diligence or one document review exercise, but we only need to do it once, we don't need to do it 300 times. So in my most cynical times, I say we shouldn't confuse training with exploitation. The reality is, using junior lawyers to do that routine and repetitive work is not fundamentally motivated by training, it's motivated by that pyramidic structure that you mentioned. That's the way we make money. We have to rethink the way we train, because just now, in summary, and clients say this again and again, what essentially we're doing is asking clients to pay for the training of the junior lawyers because they're paying for their services more than they're actually worth. And
so, yes, but the alternative to that, or really what you seem to be heading towards, is let's fire all the junior lawyers because we can't pay them, and let's outsource everything to India for the routine and repetitive work. Now, you know, the medical profession, the intern in the hospital does routine and repetitive work. And as a matter of fact, the patient likes that. I mean, when I talk to the surgeon before the operation, I ask him, how many times have you done this? And he says, oh, way back when I was an intern, I started doing it. And but you've referred to an alternative multi-sourcing, and part of it is outsourcing to India or other places. Is that really going to be a total answer? Suppose the dollar declines in comparison to the rupee. Suppose Indian prices rise. Pretty soon the Indians will be charging what the large law firms are charging.
There's going to be some interesting issues emerge following from these observations. I have no doubt. To be absolutely clear, outsourcing legal services to India is one of a variety of options. The notion of multi-sourcing, which I've invented, is to suggest basically that where historically, if a client had some legal work to do, they had one way of sourcing the service. They could send it out to law firms, or they could do it internally. Now there are many more options. Now, I think one of the most dramatic options we see in the marketplace just now is outsourcing to India, and we are seeing, for example, document review and litigation, large-scale documents done by very skilled and able individuals, done for maybe a fifth, a seventh, even a tenth of the price. But I'm not saying that that's the only way, and I'm not even saying that that will remain the dominant way of sourcing alternatively. So when I talk about multi-sourcing, I'm saying, for example, we could use more paralegals, or we could transfer work from expensive cities where there's all the overheads and higher labour costs to less costly areas within the country. That's relocating as a way of sourcing. We could subcontract work to other law firms, and again, in different locations where the costs are lower. So the philosophy of multi-sourcing is to say, just before you think, client, the only way that your entire service can be delivered is by one law firm in an expensive city from expensive property, just think you could break down the tasks, and some of these services could be offered in different ways. I'm terribly conscious that many people want to give arguments essentially in opposition to outsourcing to India, and therefore they think the only alternative is to go back to business as usual. I'm saying, hang on a second. What about subcontracting? What about use of paralegals? What about computerization? In many ways, my book it's a philosophical point. It's about changing one's frame of reference. The assumption that law firms do all the work should be challenged on all occasions. To go back to your earlier challenge, it's not an all or nothing thing. I think we will continue, of course, to have junior lawyers, and they'll be very important, and they'll still, it seems to me, provide very personal service and so forth, and they will, I think, be trained in different ways. But I think there will be less of them. I think the base of the pyramid will reduce in size. I'm not saying get rid of all junior lawyers.
Because we need senior lawyers, and where we're going to get them from except from junior lawyers.
Well, of course, that's a challenge. There's also an interesting question, however, whether or not we have too many lawyers. I mean, in England, we take into our law schools about 15,000 new law students every year, and we don't really have a notion of what these lawyers will be doing in 10 or 15 years' time. It's interesting, when I was studying law in the late 70s, early 80s, we had some confidence. We lived in a time where, for the foreseeable future, a legal service would look pretty much like it was then. Today it's very different. Today, with the advent of information technology, with the commercial pressures, with new ways of sourcing and delivering services, no one really can confidently claim the legal services market will look like X, Y, or Z in 5 years' time, still less 20 years' time. And so I think, and this is a challenge I think for our law schools, we just need to be open-minded, as I said earlier.
Let's just move on to the internet and how lawyers in the digital age are using the internet in ways they never used it before. And I think in your book you mention a number of different things that have arisen, and perhaps you can go into that, resolving disputes on eBay, legal Zoom, which Bob Shapiro started, who was involved in the O.J. Simpson case, Twitter, Facebook. What do you see as how this is going to play out?
First of all, it's early days, and I want to stress this. And it's interesting, actually, when I make predictions and I say it'll be 10 years, often enthusiasts say, no, it's going to happen in 2 years. Well, in fact, not. Although the technologies are in place culturally and organizationally, it takes a long time for the legal profession to change, but we are seeing, and you've hinted at some of them, some very significant new developments. You mentioned LegalZoom. Over 1 million users. That's people getting legal documents online. And these are people who often would otherwise not be able to afford legal service at all. So I think it's a fundamental social function. You mentioned eBay reported that 60 million disagreements between users of eBay arise every year. Now, these are not resolved in the courts. You use online dispute resolution, ODR techniques for that. And I'm saying if we can do this in eBay, and I think it's admirable that it's done in that way, why can't we do this in different commercial contexts? You mentioned Twitter. A couple of years ago, if we'd been having this discussion, we wouldn't have heard of Twitter. Now there's over 100 million users. I often get the sense with lawyers, with something like Twitter, they're waiting for it to take off. But frankly, with 100 million users, I think it has taken off. And lawyers say to me, well, in law firms, well, why is it relevant for us, Twitter? Tweeting, it all sounds rather immature. It's the playthings of our children. I know many general counsel and in-house lawyers now who are tweeting, sending out messages about where they are, where they're going, what they're thinking, what they're doing. Now, if I'm
having lunch with a colleague and we're racking up some billable hours. So.
I'm not sure they divulge in that way, but if my clients are sending out regular messages about what they're thinking, where they're going, what they're doing, and so forth, I would want to be part of that, even if the mechanism, the medium, is a slightly daft name. So lawyers, again, it's an open-mindedness point. Why don't they think, well, we can embrace Twitter and we can actually have a broader communication channel with our clients? Or Facebook fascinates me. 500 or 600 million users of Facebook. Again, most lawyers will think, or partners in law firms will think, well, that's just for my children. Over 50% of almost every law firm I've looked at, the members of the law firm use Facebook.
And you and I are on Facebook.
You and I are on
you
Facebook.
and I are friends on Facebook.
But we're unusual because most partners in law firms are not on Facebook. In fairness, most junior lawyers on Facebook don't use it for business purposes. But my challenge is this: what's Facebook about? It's a way of putting information on the internet about yourself. It's a way of maintaining and growing a network of contacts. It's a way of communicating and collaborating more effectively. Why would lawyers not want to use that kind of technique? Why would law firms not want to use the latest, the best, the most effective ways of maintaining a network, of collaborating and communicating more effectively? I think in 5 years' time, lawyers will be using, we may not call it Facebook, it might be LinkedIn, it could be Legal On-Ramp, which is one of the first dedicated, essentially, social networks for lawyers. Doesn't matter which one it will be for me, but I think in 5 years' time, we'll have embraced that. And if you or other lawyers listening are skeptical, I just go back to 1996 and email. Frankly, email was way less likely in 1996 than social networking is for lawyers today.
Well, Richard, this has been absolutely marvelous, and I'm afraid we have to wrap up on the note that lawyers are going to be using Facebook and Twitter and all sorts of other vehicles in order to confer, communicate, and collaborate and better serve their clients. So thank you for coming by, and thank you for coming by. Tune in next week for more on the digital age. Please visit our website at www.digitalage.org, where you can see all the past shows and find out what's coming up next. For the digital age, I'm Jim Zirin. Good night and all the best.